is Dr. Muhannad Alazzeh. Sorry if I say it wrong. He is the Secretary General of the Higher Council of the Rights of Persons with Disabilities and Jordan's representative in the UN Committee for the Convention on the Rights of Persons with Disabilities. He is a former member of the Jordanian Senate, where he has served on multiple committees, including the Legal Committee, Women's Committee, and Human Rights and Freedoms Committee. He earned his bachelor's and Master of Law degrees, as well as his doctoral degree in criminal law and bioethics at Alexandria University in Egypt, and completed postdoctoral studies in governance, democratization, and public policy in the Institute of Social Studies in The Hague, Netherlands. I wish you very welcome from Jordan, Dr. Muhannad, and the floor is yours.
Please, audio now unmute.
Thank you very much, Meta, and thank you for having me here in order to make my humble intervention about something is quite not only important, but it's the core of the CRPD, as may you all noticed from Tina's presentation. Now I will start to share my screen.
Layouts and options are shown.
Just give me a minute.
Virtual PC. Document. Zoom meeting. To move to an item, press the arrow keys. View button. Alt S. Layouts and options are shown. Select hide layouts and options. Share screen button. Enter. Show thumbnail video selected. Screen sharing meeting controls. Screen sharing meeting controls. Mute. Currently unmuted. Alt plus.
Is it shared now? Can you see the presentation?
Yes. Yes. Yes, we can see you. Thank you.
PowerPoint slideshow dash left bracket 1. Slide 1 dash the
Now,
status quo of it.
what I'm going to do after listening to the UN standards and the whole background about the related general comments of the CRPD, as well as the guidelines on Article 14 and 19, we want to really see the implementation at status quo, to what extent these standards are interpreted, translated, mainstreamed at the national level. And I will provide some examples, thematic examples from some interpretive declarations, from some national legislations from different regions, regions who are different in their legal and social context. This maybe would help us at the end to deduct the common elements that make state parties from different regions with different cultural and social context to have the same quote-unquote concerns, or as they perceive them, to have the same declarations, reservations, discriminatory legislation. And then I will end up by way forward. What can we do in order to maybe overcome these common, like misconception regarding legal capacity, first of all, as one of the main, I would say, reasons from their point of view to enforce psychiatric coercion or forced treatment and forced hospitalization. First of all, in the CRPD, as was mentioned before, I will here just mention that if you look to the CRPD, from the preamble to the end, you will find key and cross-cutting or transversal principles confirm, reaffirm, emphasize all elements that confirm or indicate that
All cases left the meeting.
forced treatment or psychiatric coercion and institutionalization is a clear violation, and I would say a clear crime. I mean, with no doubt.
Slide straight connector graphic.
So
Transversal principles.
when the convention in the preamble confirms individual autonomy
Individual autonomy and independence.
and non-discrimination,
Semicolon.
freedom of choice, and then it's reflected clearly in the general principles in Article 3 of the convention,
Equality and non-discrimination, semicolon.
and
Legal capacity.
then reaffirmed once again in a different context, but with the same content in Article 5 regarding non-discrimination, and detailed in a very clear language in Article 12 regarding legal capacity, then there is no doubt that the purpose of the convention, general principles, and the spirit of the convention, it's all about ensure full legal recognition for persons with disabilities, and also full legal recognition for their legal capacity. And of course, this includes their right to freedom of choice and individual autonomy.
Slide 3 implement straight connector graphic. Implementation of obligation :
all these concepts and the principles,
4 general left quote states.
the convention clearly in Article 4 indicates that it's not only a theoretical aspect or theoretical issue. It's something must be interpreted to obligations. And this is why in Article 4, the CRPD gives the state parties clear pathway, clear obligations in order to make a full legislative reform, in order to mainstream and implement the said principles and the said concepts in their national legislation. So, and this means that the CRPD, and we will also come to that later, the CRPD, when adopted, whether the state party is a dualist or munist legal system, when it's adopted, then it became the law which supersedes whatever contradicts with its principles or with its detailed provisions.
Left parent, right parent to take all appropriate measures.
So
Left parent.
after, I would say, approximately 16 years of entry into force of the convention, where are we now regarding all these principles and provisions?
Are these principles and obligations? Are these principles and obligations recognized at the national levels? Document. Slide 5 and general obligations. Slide 5 examples on interpretive declarations regarding legal.
Now we have
general straight connector graphic examples on interpretive obligations.
Some
obligations.
I would say, as I said, interpretive declarations from different countries, and they were not, or they are not being removed until now or withdrawn, which means that there is something, or there is a lot actually to be done at the national level.
Slide straight connector graphic. Racial straight Egypt. Left quote the Arab.
If we look to Egypt, interpretive declaration, and Egypt is an example which is applicable to the majority of the legal system regarding civil codes and personal status codes in the Islamic and Arab countries. This interpretive declaration, I would say, is clearly reflects not only misunderstanding about legal capacity, but it also reflects I would say, frankly, a discriminatory approach against persons with disabilities. This interpretive declaration says simply that legal capacity is recognized only for persons with disability, is recognized in its part, which is the legal capacity for rights. And for those who are not, maybe those who are lucky, and they are not really, I mean, lawyers or legally specialized, legal capacity in most of the legal system, it has two main parts. The legal capacity for rights, which means that uh, everybody upon birth, I mean, automatically by different types of laws, international laws, natural laws, national laws, acquire the basic rights and the freedoms, like the right to life, right to health, education, and so on and so forth. The other part, which is quite important, is the legal capacity to act, meaning that the person shall conduct and perform all legal actions and even other actions independently through full individual autonomy. According to this interpretive declaration, unfortunately, this state party indicates that they understand the legal capacity in Article 12, its capacity for right, which is in Arabic ahliyat wujub. Ahliyat is capacity, wujub, it's for rights, but it's kind of pure legal term in Arabic, and not the capacity to act, ahliyat ada, the capacity to perform, as it's literally translated here. And what is really strange about this interpretive declaration, I was in the ad hoc meeting during these debates about the legal capacity, and this state party concern, as they indicated, was about persons with intellectual disability and persons with psychosocial disability. But if you look to the declaration, it's about all, actually. Of course, I mean, even if it's about intellectual or psychosocial disability, it's fully discriminatory. But I would say this language of the declaration reflects general understanding and general stereotype about persons with disabilities, regardless the disability kind or type. Here, also, there is interpretive declaration from Norway, which is highly advanced in the human rights, I would say, fields and aspects in comparison to other countries. And if we look to the difference between this interpretive declaration and the previous one, okay, I mean, there are some phrases it indicates that state party recognizes the support for persons with disabilities and their right for legal capacity, but still, I mean, they put this exception that the withdrawal of legal capacity is something could be necessary. And what I noticed also about this declaration, and we'll see the same or similar language in other declaration, that it says we understand that the CRPD allows guardianship or allows withdrawal for legal capacity. And for me, this is really very, I would say, important and serious alert, because the CRPD does not allow. And again, this brings us again to the interpretation and how each country or each state party understands or interprets the convention based to their national legislation. And the opposite should happen. State parties should harmonize their national legislation to the CRPD, not to harmonize the interpretive of or harmonize the CRPD through subjective interpretation to be in conformity to their national legislation. Otherwise, we give superiority to the national legislation over international binding treaty, human rights treaty. Another interpretive declaration, it's on Article 14 and 25 together. Also, it says that Norway understands that the CRPD allows compulsory treatment. And having these two interpretive declarations on 12, 14, 25, it's not by accident. It's not coincident. It's something carefully contemplated because, I mean, they understand and they know that these articles are interrelated and connected robustly to each other. Ireland, they have declaration and reservation on Article 12, and it has I would say, some extent, the same content of the previous declaration of Norway. And also, they use the word that they understand that the CRPD permits the decision substitution and guardianship.
Article 12 may be interpreted as requiring the elimination of decision-making arrangements. Ireland reserves the right to permit such arrangements in appropriate circumstances and subject to appropriate.
And here, unfortunately for Ireland, it's not a declaration, it's a reservation, which means that there is a stronger political will to give the preference and the priority in terms of the implementation at the national level for the discriminatory legal provisions, not to the CRPD.
Slide 10 Ireland straight connector graphic. Slide 10 Ireland straight Ireland : declaration : articles 12 and 14.
Also, Ireland on 12 and 14,
recognizes that all persons with disabilities enjoy
they have
the person and the right to respect for physical
the 12 and 14.
Can someone please quote all integrity on an equal basis with others. Furthermore, Ireland declares its understanding
And here,
treatment of.
it doesn't, I would say, make the interpretive declaration or the reservation good or nice when you give this chapeau at the beginning and say that, oh, you know, we do recognize the right to liberty and the right to legal capacity. Nevertheless, also, but we will enforce the compulsory or involuntary treatment and hospitalization. There is a clear contradiction between in the declaration itself, in the language itself, and again, there is a very strange position, and there is upside down, I would say, legal effect between the national and international law, because these declarations and reservations, actually, I mean, they supersede the provisions on the CRPD.
Slide 11, straight connector graphic. Discriminatory and derogatory definition and language in the personal status laws regarding psychosocial disability from Arab and Islamic countries. Fool is one who spends
I just want you to contemplate these definitions, shameful definitions about psychosocial disability, which is expressed in a very discriminatory and derogatory language in the civil codes and personal status codes in the majority of the region of the Arab and Islamic countries. And it's unfortunately, comfortably using lunatic, foolish, fool person. And the definition, they are so subjective and discriminatory. And when I discuss them sometimes with some people with religious background, and I will tell you why religious background, how do you mean by, or how can you judge somebody that he has whatever, I mean, you believe regarding his legal capacity, because his or her actions does not match what is imposed by Sharia or by the religion? How do you interpret that? Does it mean, for example, if I drink a glass of wine, which is contrary to the religion, for example, that I should be fully or partially deprived of my legal capacity, although alcohol, it's drinking alcohol, it's not a crime in all the countries except in the region, except maybe for one or two countries, for example. And he said, no, I mean, but if the person spent the money, for example, in a very unrealistic way and blah, blah, blah. So it's all these definitions, they were put by imams, by people with religion background 1400 years ago. And they were copy paste. I read them in the original book to the civil codes and the national codes. And this is one of the main challenges in our region, to argue and to lobby and to change the legal capacity provisions, because they are deprived from, you know what I mean, like religious dogma or instructions. It doesn't mean that it's impossible, because still we have the constitutions, we have the legal power of the CRPD, but it's not easy. It's not that easy when you discuss, in a very logic way and legally with, with all due respect, of course, but with people with, like people who are running religious institutions, regardless what is this religion is, it's not that easy.
Document. Slide 12, straight connector graphic. Common notes and concluding observations of states parties.
Here, I just put some common observations. The committee usually oversee and give to state parties from different regions, from Latin America, EU, Middle East, Africa, Asia.
Adoption of the medical model.
It's noticeable that there is several countries still adopting their laws the medical model, although they believe that having laws with some words derived from the human rights or the title of the law, for example, says the rights or the human rights of persons with disabilities, they believe that this means that they already achieved the paradigm shift, which is not the case. And again, I mean, it's not basically, I think it's not due to bad intentions or something like that. It's the lack of the know-how, the lack of the knowledge. And this, entails responsibility on the committee, the UN system, OPDs, individual activists, maybe, to enhance and promote awareness raising, even to simplify the concepts and the principles, because not everybody is really specialized in human rights or in legal capacity or in psychosocial disability, including some legislators, of course, they are not specialized in these issues. We, I mean, usually notice that these countries, and this is, of course, expected, when they adopt the medical model, then always there is absolute, I would say maybe authoritarian authority to doctors, in particular psychiatrists, to decide on behalf of persons with psychosocial disabilities under what's so-called, quote unquote, the best interest of the person.
Assumptions. Discriminatory public health law, semicolon.
Usually public laws in different countries, they are discriminatory because they give either to the medical personnel or to the health personnel or even sometimes to the mayors. These public laws give them authority to institutionalize and hospitalize individuals and persons based on their disability, because they believe that these persons, I mean, they could represent like threat or danger or whatever on themselves and others, you know, I mean, the same stereotypical language. And based on these assumptions, they looked up the persons in the hospitals, psychiatric hospitals, and deprive them of their liberty.
Use of physical and chemical restraints, semicolon.
And of course, using chemical and physical restraints. And I was shocked when I heard 2 or 3 countries justifying this use. And again, I mean, some of them, for example, say, you know, but it's used based on a decision of a committee. It's not an individual decision. And it's used carefully. And as Tina said, I mean, when you torture me carefully, I mean, this does not mean that it's not a torture, it's not a crime, it's not a violation.
Institutionalization strategies do not
Something important. There are some countries, and this is something really good, they have DI, deinstitutionalization strategy. But what we notice usually, that the deinstitutionalization strategies do not include the psychiatric coercion or psychiatric hospitalization. And again, because there is misunderstanding about the deinstitutionalization, some countries, they do believe that it just goes to the residential care centers, special education centers, and it has nothing to do with the psychiatric facilities or psychiatric hospitals.
Dear Dr. We need to go in for landing. It's close to the end.
Absolutely.
Yes.
Steps must be taken. Comprehensive legislative.
Steps must be taken.
Comprehensive legislative.
First of all, before doing anything, there must be the leadership in any legislative or institutional reform. It must be led by the stakeholders, by the rights holders, by persons with psychosocial disabilities and their representative organizations. Some countries, they implement and believe in what's so-called the twin-track approach. I'm not a profound believer in that, but this, what's so-called twin-track approach, which means, I mean, should not allow or should not permit or justify all forms of violation, including deprivation of liberty or absolute authority for doctors. And also, it shouldn't justify misleading alternatives or definitions. For just very quickly, one example, I was talking to Tina before about something adopted in different countries, including in my region, what's so-called the social recovery. This means because when the court decide to involuntarily hospitalize somebody, they, in their decision, they say, and this person shall not be discharged until he or she recovered. And psychiatrists, they said, but there is no recovery from psychosocial disability. So this is why they came up with something called social recovery. And they mean by social recovery that the person has no more symptoms and, quote unquote, has no threat to the society or others.
Slide 14, that's great. Thank you.
Thank you very much. And I'm really honored to be with you and to make this intervention. Thank you.